Strata advisor, formerly Commissioner for Body Corporate and Community Management in Queensland. With me, and definitely with me today, as always, Frank Higginson, partner, Hines Legal. Frank, welcome.
Thank you, Chris. Hello, everyone. I'm glad I'm on time today.
Even though I promised I would not mention it again. Sorry, Frank. That was wrong with me. Thank you for everybody who continues to register for these events. The two big advantages of registration for these webinars. Number one, you get the automated reminders to come along. Very important. But number two, you get a little bit of content from us afterwards, a handout afterwards. And for something like today's topic in particular, that handout's going to be pretty essential, I would suggest. So yeah, please make sure that you look out for our emails about registering for these webinars. Don't forget to like and share and subscribe, please, if you get the chance to do so. Again, that just helps us be able to track what's important to people and how we can structure our topics going into the future. Today, though, Frank, we're going to delve into what I think it's fair to say is a bit of a niche area in body corporate world, and that is BMS. Now, let's clarify. Everybody would be familiar, I hope, with the CMS, Community Management Statement, for those of you who don't know, but BMS, Building Management Statement. So they're related, are they, Frank?
Sort of. Sort of. So it is a common source of confusion, and there's lots of parallels for body corporate, and there's some substantial departures from what people are used to in a body corporate context, and it's really easy to get the two confused. So, like I said, they are niche. If you've got a newer mixed-use building, you've probably got one. So if you've got an older style building, you won't have one. But the amount of disputes and advice we give on these things is extraordinary. So I suppose today is a bit of a educative sense in the terms of here's what they are. We've written some newsletters previously, but half an hour of talking about it's probably going to give a lot more visibility to everyone.
And look, as you say, Frank, it's becoming an increasingly prevalent way of development. And so if you have, say, in the last few years, bought a relatively new apartment, or you're about to, or you're thinking of it, chances are BMS is actually going to become very relevant for you. And it's important that you know what's involved. So we are actually going to get to the nexus between BMS and body corporate stuff shortly. But Frank, the $64 trillion question, what the hell is a BMS?
Cool. Now, I have some props, Chris.
Wow.
I have some props. So this is the first time this has ever happened on a webinar in the world, I'm quite certain, of someone using 2 toilet rolls as a prop.
Yeah,
there you go.
Okay. I'm liking it. I'm liking it so far.
There is a theme to this. So this, ladies and gentlemen, would be a residential high-rise tower, or a high-rise tower on a parcel of land, which eventually, without that, it's just a block of dirt. Developer comes along and builds this thing, and away we go, we've got a tower. The difficulty, and this is where BMS has come from, is that there's 2, look at this, competing uses inside this tower. The top one might be our residential units. The bottom one might be our office units or commercial or otherwise. So what has happened what has happened is the government has created the ability to have a structure that regulates the interaction of those 2 units. So the example I use here all the time is Victoria Square at Broadbeach, and not for any particular example, but for those of you who've been in Broadbeach Mall, Victoria Square is on the northern side as you're walking towards the ocean, and down underneath you've got a whole bunch of restaurants, then you've got a level of office, and then you've got residential. So what you have in that building is 3 different uses, all governed by the one body corporate. And as you can expect, that gets a little bit messy because you've got obviously a bunch of insurance risk that comes with the shops. You've got a whole bunch of lesser insurance risk that comes from the offices. You've got a whole bunch of different use which comes from the residential in relation to the pool and the like. And all of those are supposed to be happily governed by a community management statement, and the costs dealt with by the lot entitlements. So that's a very inflexible structure. So what a BMS does is allows different body corporate use types or different use types full stop to participate in some stuff together and some stuff apart. So when we come back to my little high-rise tower here, what we end up having is this lot can have its own set of rules. This lot can have its own set of rules. And what the BMS does is act, and this is, Chris, what you were saying before, as a sort of quasi-body corporate in relation to how those two relate. Because the other thing that really matters is when you're back to what is our parcel of land, is that everyone is using that land. So they're using the land to access their lots. Probably underneath that tower, there's going to be car parks. There might be some common facilities that are shared for both. So what the BMS regulates, in the same way that a body corporate has common property, the BMS regulates the right to use those areas, because unlike a body corporate where the things that aren't your lot are common property, so really, inside the front door is yours, everything else outside, for want of I suppose a far more complicated explanation, is everyone's collectively. In the relation to a BMS, someone would actually own that land. One of those lots would own that land, and the BMS would give the others the right to use it in exchange for contributions towards the costs. So if you wanted a BMS 101, that's what it is. So that's that confusing element, Chris, where it looks like a body corporate, and in some senses it is like a body corporate, but in the majority it actually isn't. So, and when you look at it from a pure legal perspective, a BMS is actually a contract. So if your lot is subject to one, it'll be registered on the title to your lot the same way an easement would be or a mortgage would be. So it's a contract that your lot is subject to. So
Frank, you and I both like food. So maybe an analogy here is that the BMS is the binding agent that brings together all of the ingredients in that dish.
That's a really good analogy. So yeah. Very Montrachet. So it's interesting too, because BMSs aren't regulated by the Body Corporate and Community Management Act. They're regulated by the Land Title Act. So for those of you that want, and Chris will put the link up, section 54C, and what that says is a BMS must deal with certain things and it may deal with other things. So things that a BMS must deal with is the supply of services to lots. So again, back into our high-rise tower, the lift is going to run possibly between both of them. So that's a service, rights of access to lots, rights of support and shelter in terms of roofing, all that sort of stuff. Insurance, which is a really big thing, because if you come to, again, our building here, it's really, really hard to insure this lot with one building, with one insurer, and this with another. It doesn't make any sense at all, but to have insurance collectively responsible for the building as a whole. And there's a bunch of other things that the BMS may deal with. And I suppose, Chris, that's where we get into another body corporate analogy.
We do, yes, we do. So maybe just for everyone who's watching for their benefit. So we're talking here about something where the ultimate responsibility rests with the registrar of titles.
Yep.
Important distinction to make.
Yep, it gets registered, and these documents aren't standard. There is no standard form BMS document. Each one is individually drafted, and it depends on the skill of the drafter as to how detailed they are. And I will say a lot of the problems that we have with them, and to be perfectly honest, it's a whole lot easier to pull them apart than it is to put them together, because when you're drafting them, usually you're doing something for a building that is yet to be built. So all of the nooks and crannies can't really be sort of taken out of the plans, usually in a rush, with a view to disclosing the respective buyers off the plan. So you're trying to craft a document that deals with a whole bunch of contingencies which you don't have visibility on. So it's usually our jobs, our legal work is more often than not looking at them after the event when the thing's built, usually when bodies corporates come to us and say, hey, we've got a problem with this, and it's very easy to see how that problem came about because the drafter wasn't aware of that particular issue at the time the building was a concept plan. So so we've got, that's what a BMS is. One of the things that a BMS may deal with, and all of them do, is how that BMS is going to be managed. Because what you've got is these lots again, get that in the thing. This might be a body corporate. This might be an individual lot owned by a managed fund out of Sydney that's into property investments. So that BMS needs to set up a separate entity to run the affairs of that BMS. So to deal with the insurance, to deal with whatever issues that come up between them. And that group's called the BMG, which is the Building Management Group. And again, so in effect, we've got, to a degree, that committee similarity where the BMG should make decisions in relation to whatever the BMS actually says it can make decisions in relation to. But one of the big differences between a BMG and a committee is we know from a committee perspective at Strata law, 7 people, certain roles, AGMs once a year, all that sort of stuff set out in legislation. The way a BMG is created and the people who are on it and what their voting rights are and what they can and can't do is dictated purely and utterly by the BMS document itself. So in a sense, if Chris was the developer of this particular property and he's sitting down here and going to hang on to the commercial lot, what he could do is build into that BMS is that no matter what, I get the right to do whatever I want, whenever I feel like it. And
so there's no obligation about fairness or reasonableness, is there, Frank?
No. It's a contract. And it's registered against your title, and that's all there is to it. So, and again, let's talk about, we'll get into how these things apply to Strata really about now, but it's really, really important to understand that. So there's some similarities in concepts between what a body corporate might do. You know, BMS is really what almost deals with the common property. BMG is like a committee, but then outside that, the document itself dictates how all of those things must work. There's no other statutory regime that will provide rules and regulations around it.
Let's talk about that body corporate link then, Frank, because I reckon a few people would be sort of sitting there going, oh, that's all well and good, but you're a body corporate law firm, so tell us about the body corporate involvement.
Absolutely. So back to our, I love my props. I'll give them the dog afterwards, he'll chew them up. So when this is again built, it'll be 2 separate, what's called this one will be a volumetric lot. So that's actually a subdivision of airspace. So it doesn't actually own any land. It's sort of these pegs in the sky, in effect, that are the property. What the developer will then do is go and subdivide that block in the sky into any number of units, in accordance with its approval and whatever it might be. So this downstairs property might stay in one line. It also might become strata titled. It's whatever. But there's always usually a residential component to these, and that top one will become a body corporate. So before it's subdivided, it might be lot 2 on SP, whatever. After it's subdivided, it's lots 1 to 150 in SP, whatever, and a body corporate is created as a result of it. So inside this bit is going to be a whole bunch of common property for that body corporate. So there might be a library space, there might be a gym, there might be whatever that most body corporates might have, which its occupiers and occupiers can use and which it regulates in its own right and which aren't shared areas and which it has budgets for and all that sort of stuff, like all the body corporates we deal with day to day. But then you've got this additional layer of the body corporate is now a party to that BMS and must usually participate in the affairs of that BMS as a representative of the lot owner, which the body corporate is. So
that's tough to wrap your head around, isn't it, Frank? That kind of thing. So in effect, put your props back up. So in effect, you've got on the top, you've got the body corporate for cardboard roll 1. With a CTS number and a community management statement and all the bells and whistles about BCCM, so committees, lots, bylaws, blah, blah, blah. But in addition to all of that, that body corporate is a party to a contract with the space directly beneath it.
Yep, which might or might not be a body corporate as well. Yep. And if you want the biggest example of this that I've seen, you go and put another 3 of these on top and another one below, and you've got Brisbane Sky Tower. That is 5 volumetric subdivisions, all joined by a BMS. It's extraordinary.
Goodness, okay.
So that obviously is complicated. So, because there's a whole bunch of diverging potential interests in there too, because there's different styles of units and all sorts of stuff.
So Frank, tell me, does that therefore mean that if I own a lot in that residential of cardboard roll community title scheme 1, if I own a lot there, I'm contributing levies to that body corporate, but I could also be contributing as part of the BMS?
You will be. because what should be in your body corporate's budget should be a line item for BMS contribution, and that BMS contribution will relate to what Cardboard Roll 1 has as an obligation towards costs under that BMS. So one of those will clearly be insurance. So from an insurance perspective, you're going to have insurance for the building as a whole, and our strata is probably going to have insurance inside its volumetric lot as well for public liability for its common property that isn't a shared area. There's going to be maintenance costs for that lift going all the way up. There's probably going to be costs in relation to the provision of car parking. There might even be contribution towards costs in relation to the shared areas, the cleaning of those. Because if we're back up here in our little volumetric space, but there's areas down here that we're using, we're going to be contributing to those as well. So there will be a line item for those costs, absolutely.
To borrow one of your phrases, Frank, riddle me this: why would anyone buy a lot in a body corporate that's a party to a BMS?
I suppose it's the joy of the facilities you're actually getting. Like things come at a cost. That's the reality. So if you go to Brisbane Sky Tower and look around there at some of the facilities, and having had a couple of meetings in there, they are beautiful, but they come at a cost. Okay. So if you want to be in that part of town, in that style of building, et cetera, there's a cost of occupancy that comes with a building of that nature. And if you don't want that, then you can buy in a three, and obviously there's management rights and there's facility management and there's all sorts of technology whiz bang in that one particularly. If you don't want that, go buy a unit and a six-pack in suburban Brisbane somewhere and absolutely not pay the same cost, but don't have the same amenity.
Which leads us very nicely onto the topic, what can go wrong with a BMS, Frank? And I think we already highlighted one of the issues. What else can go wrong with a BMS?
Yeah, I think probably for me, there's three things really which would be the core of most of the issues that come across our desk. The first one is people just not understanding them. They don't understand what they're in. And that's particularly from a committee's perspective. This is, and again, what you might have in a BMS, or what you will have in a BMS situation with a body corporate is you've, as a committee member, you've put your hand up as a volunteer to be involved in this strata thing that you might not understand. And usually the default position might be the chairperson of the committee is the body corporate's representative at BMG level. So suddenly you're dealing with a BMS that you also don't understand. So the double whammy of what the hell is all this stuff? And that, again, that's what we're doing these things for. The other thing is probably then assuming that you've got your head around the two different hats that you might be wearing. The other one is actually understanding the rules about the BMS. And there is no shortcut there but to read the thing, really, because they are all different. And what I say to clients all the time, they ring me for a quick off the cuff, what do you think about this with a BMS, Frank? It's just stop. Everyone is different. There is guaranteed everyone is different. And it might only be in small respects, it might be in larger ones, but there is no shortcut but to actually reading the thing and understanding them. And that's particularly around cost contributions. Because one of the joys of a BMS, I suppose, is the flexibility you have in relation to costs. So from a body corporate perspective, we have the contribution schedule lot entitlements. That is your proportionate share of all of that body corporate's admin costs, regardless of your use of them or otherwise. End of story. No two ways about it. A BMS, you can actually create costs or charges in relation to specific areas based on potential use. Sometimes you can have the ability to adjust them, and you can relate them to the specific areas. We've got down to the detail on one, which we renegotiated for a client, in terms of electricity costs, where we actually went and counted the power points. It wasn't us physically, we had a QS go and do that for us. But and the power points were the proportionate share of the electricity costs between the respective lots. And there was a mechanism there to adjust it if people introduce new ones. Like that's how finicky you can be. You can't do that under a CMS, the bylaw. You simply cannot do that from a legislative perspective. You can look at insurance, you can look at, like I said, electricity, you can look at cleaning, maintenance, all sorts of things based purely on whatever your methodology is that you want. So the flexibility, and you're back to that Victoria Square example, that rather than have, and one of the issues that'll come up there every year, no doubt, is insurance, because again, a whole bunch of retail traffic is a different insurance risk to office, which is a different insurance risk to residential. And inevitably that body corporate's probably paying a lot more, but the entitlements are really the way to adjust that. Whereas under a BMS, you can do them specifically. but you need to read the thing to understand what it is, because it's the other problem, mate, is the people that put these together, the development lawyers and even the development consultant that the strata managers usually then pass it over to the committee and a new strata manager who does day-to-day operational stuff to run the things, and quite often no one's read it.
Yep.
And that year on year can add up to a whole bunch of mistakes.
It sounds like it.
Yeah.
So, okay, so I've got a problem, or I've got some issue, or I need to find out a bit more about my obligations, rights, responsibilities under a BMS, Frank. So I can just toddle off to the Commissioner's office, I guess.
No.
No?
No. All of these disputes and all of these issues are really a titles office issue. So you're off to the titles office to firstly get a copy of your document, which is easy enough to do. I mean, yeah, we can press a button and $40 later, we've got it here. But the other one is from a dispute resolution perspective. The Commissioner's office has no jurisdiction at all in relation to a dispute under a BMS. So it might in relation to how a committee deals with its, I suppose, who gets pointed to the BMS committee, as an example, in terms of which person might go up, because that's a committee decision, all that sort of stuff. But when it comes to issues under BMSs as a whole, you're outside the Commissioner's office jurisdiction and you're in the court regime. So,
Goodness me.
yeah, it's very messy. So litigating these things is, you need special resolutions. And dare I say it, Chris, I think we'll talk about mediation is one way, because most of these BMSs include a dispute resolution mechanism, which says before you charge off to court, you must follow this process. And that process, again, is document specific. You never know where, who's drafted it, what their precedent was, and all that sort of stuff. So you can follow those things through. And that's certainly, we've got a couple of proposals out there for BMS mediation.
Yeah, we've seen a couple, haven't we, where there's some standard wording in a few which talks about requesting the Queensland Law Society nominate somebody appropriate to resolve that dispute.
Yep.
In others, I've seen where it's actually up to the parties to the BMS to nominate and agree on someone. Doesn't say who that someone needs to be, or what their qualifications, sorry, need to be. So there are a bunch of different ways, aren't there? But so really, when it boils down to it, if Cardboard Roll Community Title Scheme 1 and the commercial underneath it have a dispute about the payment of insurance and they can't agree, they're off to whatever the BMS says about resolving that, aren't they?
They are. And that might be as simple as we want to be insured with insurer A. No, we want to be insured with insurer B. That's part of what the BMG has to make decisions about, insuring the building as a whole. So those sort of disputes, so yeah, it's sort of, this is definitely mediation territory. Probably the other things that we see that come up a lot is really the management of the BMS. So another parallel is a BMS and a BMG really is like, but isn't, a body corporate in the sense that you've got, because the parties to the BMG are actually the owners of the lots, you know, Cardboard Roll 1, Cardboard Roll 2. So Cardboard Roll 1 is Irons Towers, CTS, whatever. Cardboard Roll 2 might be whatever it is, limited out of Sydney, that's the fund manager. And there might be more lots in there. You know, so if you go to Brisbane Sky Tower, there's 6 people or 6 entities, 5 of which are definitely bodies corporates that are members of that BMS. So the parallel there is you've got effectively a group of owners, you've got a committee which runs it. That entity should have its own books, records, administration, and everything. Now, we see it a lot. And I know the first time I wrote a newsletter about this, I sort of got hauled over got called for a meeting with one of the senior strata managers in the state at the time, said, what are you saying about this? Because what tends to happen, everyone tries to save costs, which is fine, and they tend to run all of the BMS costs through the body corporate's accounts. So what that means is that, say, for example, here we are with insurance again. We've got a $100,000 insurance policy. 60,000 of it is residential, is body corporate's responsibility, 40 of it is the commercial's responsibility. What tends to happen is it'll be paid out of the body corporate's accounts and recovered from this one. So in effect, to me, that is using the body corporate's accounts for non-body corporate purposes, because that is a BMG expense.
Yes, it is. And so that potentially, that's where an adjudicator could get involved to dispute those decisions made at that point.
Yep. And what happens if the commercial downstairs doesn't pay or is late in paying?
It's civil proceedings then, isn't it?
It is, yeah. And yeah, let's not talk about how easy it is to commence proceedings in relation to a BMS from one lot owner to another. So those things, it's just, and I know and I get it, and I'll probably have people still emailing me in 12 months' time off the back of this saying, how dare you say that? It's a cost thing, I get it, but it's a structure thing too. They aren't the same beast. You might as well use the body corporate accounts to run my home accounts here. Pay my rates, pay my levies, pay my insurance, and I'll reimburse you when I'm ready. Because it's not a body corporate expense. It's a BMS and a BMG expense. And even then, from a tax perspective, and Stephanie, I know you're watching, they're not really partnerships. They're separate tax entities as well. So the registration in the right way is really, really important. So, and a lot of this gets lost in the wash. It really does. And that's that handover, particularly for new buildings, you know, new committee, everyone's sort of 2 years later, they look up and say, what's happened? And this thing could have been running the wrong way for that entire period.
Yep.
And my horror story for that one is one down the Gold Coast where we're acting for a residential body corporate, it's a commercial body corporate downstairs, all owned in one line, pre-GFC. So this is how far back we go. Chairperson rang me and said, Frank, we got a problem here. So what's that? I said, oh, well, we've been paying electricity for the commercial guys downstairs and they haven't reimbursed us for 6 months and now they're all insolvent. So what do we do? It's like, oh my goodness. They ended up, the liquidator on that one ended up coming good, which was handy. But if they hadn't, that's suddenly a $100,000 expense to the residential body corporate that isn't in its budget. It's a bank then. It's not a body corporate. Anyway.
Sounds to me, Frank, like the government should do something about this.
Well, Chris, would this be the time to talk to government about doing something about this? Because the other one we get is the unfairness of these documents. You know, it is some of the ones are drafted really well, to be fair, and thoughts put into them. That's probably from experienced people. But if the developer goes cheap as chips conveyancing to get their off the plan stuff done, and someone just gets a precedent from somewhere and pulls it out and punches it out, and then that body corporate and all the lot owners and the commercial lots are bound by that document, which just doesn't cover what it should cover, that is a never-ending story. And there is no ability. The unfairness of these things, sometimes you look at them and go, crikey, how did that happen?
That's right. Interestingly, though, Frank, it's been a bit, it's gotten a bit of coverage in the last 6 months in Parliament, of all places. There was a question without notice to the Attorney General about BMSs and the unfairness of BMSs raised by one of the Green MPs, as it so happens. So I think my bold prediction, I think you agree with this, Frank, is that BMSs may yet end up on the agenda to be looked at in this term of government. What is the solution, though? That's anybody's guess, really. It's a difficult, I think you'd know from what we've talked about today, that's a difficult one to untie. But I think if you are part of a BMS at the moment and you're sort of grappling with a few issues, there may be some attention about to be thrown your way. What do you reckon, Frank?
The slow grinding government attention, but attention nonetheless, because we are going through strata law reform. So this, as much as we said at the start, this isn't purely a body corporate issue, but inevitably all of these things have a body corporate as a member of it somewhere.
Yep. That's
the reality, because they are all turned into sort of these high-rise subdivisions, and residential is the way to get that distribution out there. So the fundamental unfairness and even the inequitability of some of the cost sharing arrangements is extraordinary. And
look, even if you accept that it's not a strict Commissioner's Office issue, the fact remains we're talking about the same concept of a community that has been created in which you've got a group of disparate people, some of whom are in a difficult position or are going to be in a difficult position, and how do you respond to the inevitable consequences of that? It's the same concept.
Yep.
Yep.
Absolutely.
Yep. So in the interim, though, I guess what we're saying to people is, Frank, you need to seek some qualified advice if you've got a BMS query.
I think so, because like I said, off-the-cuff advice on these things I just don't give. It's impossible. I mean, you suppose you ask either of us questions about the BCC Mac or modules, even though the module's now a bit harder with the new numbers. You normally can spit it off the top of your head, oh, well, that means this. With BMS, you never can. So I think if there's ever one that you actually want to get some proper advice on to understand, and always like this, if you've got an issue or a concern or a worry, it's where do you stand now? What are your rights? Where can you go? And more importantly, sort of a now, where, how. This is where we are. This is where we want to get to. And the art in law, in a sense, is how do we actually get there? So, and that's negotiation. So that the PowerPoint one I gave was an example of one that we helped a body corporate get to a stage where the other side wanted to negotiate. So the art sometimes is finding what is that trigger. It wasn't brutality, it was just commerciality. So, and that now is a happy outcome.
Absolutely. I've just put a link up there about a BMS 101 that Frank, you wrote in the past, an excellent document. I've read it myself. So have a look at that one as for your overview / primer on the issue. I think the best way that we can finish off, because we have run out of time today, is if you've got a BMS related query, you're either in one or there's some issue involved or coming up, you do need to seek qualified advice on that. There's no substitute for it in this case. Drop us a line. We'll see what we can do to assist. Gosh, time flies, doesn't it, Frank?
Yet again, mate.
Yep. On the world of BMSs. Thanks everybody for tuning in. Next week, stay tuned for the topic. We will be in April for next Thursday's webinar, which means a brand new set of webinar topics for April. 5, count them, 5 webinars in April, which means we're really going to be under the pump, Frank, but that's okay. We're resilient people.
And we've got some really interesting topics. So I think we're finding our groove with this now and actually planning a little bit better. So yes.
We've got some good ones that I reckon people are going to get a bit out of, and a few thought-provoking ones too. But anyway, please stay tuned for our update on that, which will come out to you early next week. And that's, again, the whole benefit of registering for reminders to attend these webinars is you get that one as well. For now, Frank, thank you, and thank you for the props in particular. That was really cool.
No worries. Thank you, Chris, and thank you everyone for joining us yet again.
Thank you. We'll see you next week, everyone.
Bye.
Bye.